S7 on expungement. And would it be preferable to have the redraft on our screen sharing to go over and see where people have issues? I forgot to say, this is Senate Judiciary. We're taking up S7 on expungements. And it is February 23rd, one day after George Washington's birthday. So why don't we go through it's a 23-page bill, and I didn't print it out at this point. So go ahead, Bryn, if you could.
Okay. So good morning, committee. For the record, Bryn Hare from Legislative Council, here to talk about draft 1.2 of S7, the expungement bill. Can everyone see it on my screen okay?
Yes,
See it on your
thank
screen,
you.
I mean. Okay, so this bill, I just wanted to preface my remarks this morning by saying that I did send out a draft 1.1 of this amendment last week, I believe, or maybe it was Sunday. And this draft 1.2 is substantively the same as draft 1.1. I did just make a couple of technical changes at the request of Mairead and some other witnesses, I believe. So for all of the witnesses who are concerned that this might be very different, it's not. It's substantively the same as what was sent out on Sunday. So I'm going to just jump right in and start with the first change, which is, I believe, on page 3. And this is that I've removed the strike through of subdivision B for that cross-reference to grossly negligent operation of a motor vehicle resulting in serious bodily injury or death. The committee will remember there was some discussion about that. What was supposed to be a technical amendment may have had a broader impact, and so we fixed that. So I'll move on to page 4. This is a new section that was put in at the request of Mairead from Legal Aid. And if you remember, this is the new language on the surcharge. Makes a change to this statute in the fines, costs, and penalties chapter of Title 13. And the intent of this language is to operationalize that change that you made in the miscellaneous judiciary bill last year that provided that courts can waive surcharges associated with petitions to seal or expunge. So this language really is just intended to operationalize that change that you made last year.
Somebody leaving a long message on my phone. I muted myself. Any comments on this change from anyone? Okay.
Okay. So I'll keep going. Quite a bit of scrolling here. Apologies. So the next change is on page 8, and this is a change to the definition of subsequent offense. And this is really clarifying that a subsequent offense is the conviction of a crime, a later crime that is committed by the person who's petitioning to have their records sealed or expunged. And so that just tightens up that definition. So it does not apply to charges, subsequent charges. It only applies to subsequent convictions.
Bryn,
Comments? Yeah, Senator Benning.
sorry, I think that was me, Dick.
Oh, I'm sorry. Senator Baruth, how could I mistake two of you?
So does that mean that someone could be currently charged and in the process of being adjudicated, but not yet convicted and be allowed to seal or expunge?
Depending on the circumstances, yes. So as you know, the expungement section has various timeframes that are associated with being able to petition for a sealing order or an expungement order. So if a person was charged and being adjudicated, it's possible that they may have that petition be able to move forward. You may want to hear from other people who are, like Judge Gerson may have a comment on that.
Yeah, that sounds a little, this is where I'm a little confused. So just so I'm clear, I was convicted of automobile theft, grand larceny of an automobile. And then 10 years later, I asked to have it expunged, but I've got a conviction for the same offense pending. Does this say I can get my old one done?
So again, I think it's, as you know, the statute is so complicated with the timeframes that it sets out, that it would depend on how long it had been. So subsequent offense sort of starts the clock for waiting for eligibility for being able to seal or expunge. So depending on the time frame, it's possible that yes, you would be able to if you were just charged with another offense and hadn't yet been convicted, depending on how long it had been.
All right. Any comments from anybody in the audience? James Pepper, State's Attorneys.
James Pepper from the State Attorneys and Sheriffs. Thank you. That is true. The situation that you laid out, Senator, would be true. There is always the ability. There is some discretion with the state's attorneys to not stipulate to the petition. For instance, if there was a pending charge that looked pretty likely that it was going to lead to a conviction, that person would then be entitled to a hearing where the state's attorney could lay out his or her objections to the granting of the expungement. And ultimately, a judge would decide one way or the other whether granting that expungement for that 10-year-old conviction while there was a charge pending was in the interest of justice. So there are some checks and balances that would remain even with this language.
Can somebody get their arrest expunged if they weren't found guilty?
Yes, that's dealt with in a separate section of the expungement chapters.
That's what I thought.
Right. Yeah, that's
So-
almost, that's a very quick expungement without a waiting, with only a 60-day waiting period.
Yeah. Especially in today's, do the state's attorneys support this language or oppose it?
Our support of this language, I think it is a helpful clarification about what subsequent offense means, because I think that the way that the statute currently is written leaves some level of interpretation that can lead to some of the disparities. But I think this highlights a subsequent part of the bill about who can stipulate to early petitions, whether it should be both the state's attorney and the attorney general, or just the state's attorney, or just the office that prosecuted the offense, because that office will know about these kind of subsequent offenses better than perhaps the office that's not prosecuting or didn't prosecute the offense. So the short answer is yes, the state's attorneys are supportive of this provision.
Senator Sears, this is Judge Grierson. For the record, Brian Grierson, Chief Superior Judge. The way that Pepper just described the scenario, if a petition came into the court and there was a charge pending and there was no agreement by the parties, the court would have to look at whether or not it would expunge in the interest of justice with a charge pending. And I'm depending on the nature of the offense, the history, the court would have that discretion. So the way he described it, it would be the way I would also interpret it.
Do you have okay, thank you. Other questions, comments before we move on? Okay, section 3.
Okay, I'll move down to page 9 on section 3. And in subdivision 2, this is new language that we were just talking about with respect to the office that prosecuted the offense. So this language was suggested by the state's attorney's office, notwithstanding any other provision of law. Only the office that prosecuted the offense that's the subject of a petition can stipulate to that petition prior to the date that the offense is eligible for sealing or expungement.
Um, any thoughts on this one from any of the committee or witnesses?
Senator, if I might, David Chair with the Attorney General's
Yeah,
office.
David.
I just wanted to remind the committee, we already had a back and forth on this, but I did want to remind the committee that this is a section that we object to for the reasons I spoke about last time we discussed the bill with respect to allowing the Attorney General's office to serve as another entity that can process these expungements, especially where there's high volume in some counties. And although we have not and would not attempt to overrule the state's attorneys, I think having that ability for there to be another entity looking at these possibilities does help promote statewide consistency and lower disparate outcomes. So for those reasons, we do object to this.
And Senator, this is Marshall Paul from the Office of the Defender General. I'd like to chime in also. We object to this provision for basically the same reasons the Attorney General's office has mentioned. I mean, I think what we've seen around the state is, at least at different times, given different states' attorneys, there has been, all kinds of reasons why states' attorneys' offices have been unable or in some cases unwilling to stipulate to expungements, but the Attorney General's office does. And sometimes that's just a matter of resources. I mean, we've approached states' attorneys regarding stipulated expungements and had the state's attorneys essentially say they don't have time to deal with that problem, and then approached the Attorney General's office and been able to negotiate a stipulated outcome that really wasn't, nobody objected to it. It's just that the state's attorney's office didn't want to deal with that process at that time. So I think that to the extent that we don't have the Attorney General's office having the ability to stipulate to these expungements, it's really just going to increase geographic disparities. There's going to be state's attorneys who approach these differently than other state's attorneys, and the AG's office can serve as sort of a backstop to provide sort of one unified, sort of option of last resort and option for state's attorneys' offices that would otherwise be overwhelmed with petitions. So we certainly don't support this amendment. And honestly, frankly, I don't quite understand the objection or the reason for including this amendment. I mean, I guess I gather that there's a concern among state's attorneys that the AG's office will stipulate to expungements that the state's attorneys wouldn't stipulate to. I don't know why that can't be worked out between the state's attorneys and the AGs. I mean, I can't imagine that the AG's office would really want to, engage in that type of conflict with the state's attorneys, nor that judges, if that kind of conflict was evident, would actually be finding it in the interest of justice to approve a stipulated early expungement unless somebody was being totally unreasonable. To me, this just provides a really important backstop and a means to make these expungements a little more consistent around the state.
Senator Sears.
Yes, Senator White.
So I understand the why the Attorney General might be able to be a backstop here and be included, but the way I read this is that leaving the AG out of this, the way I read this is that if an offense was prosecuted in Essex, this Chittenden state's attorney couldn't stipulate. So maybe we just add something in here that says, other than the AG's office, it can only be only the office that prosecuted the offense, because I don't know that it makes sense to have other state's attorneys' offices stipulating to the expungement petition. So I don't know if that helps or muddies it at all, but
To me, that kind of muddies it in a way.
I mean, you wouldn't want.
Here's the problem that I see here. We've had these days, like in Lamoille County, for example, if the prosecutor and the attorney general decide to hold a expungement day, and somebody from Caledonia County arrives, does this mean that they can't have their record expunged on that day?
Could I
Yeah,
respond to that?
yeah.
So it would be fact dependent. What this amendment is saying is that this only applies when someone wants to waive the waiting period. Like the example you gave earlier about the grand larceny over $900. If someone showed up, there's a current waiting period pursuant to this bill, I think of 7 years or 10 years. And if someone wants to show up after a year, and the attorney general is willing to stipulate to that petition, his office would have been the one that had to have prosecuted that case in order for him to stipulate. If it was, all this is saying is that in order to waive that waiting period, which I think there's certainly evidence to show that the waiting period is an important aspect to expungement, then it has to be the prosecutor's office that prosecuted the
Well,
case.
I do think that the language should be clearer, that the only thing we're talking about here is the waiting period.
It's on line 18. That's what we were trying to get at, is that may stipulate to the petition prior to the date the offense is eligible for sealing or expungement.
In my reading of it, I didn't understand.
That's all.
I think it should say a petition to shorten the waiting period, or whatever the term is we use.
That would be fine. The intent is not to remove the attorney general altogether. It's just for the petitions that are trying to waive the waiting period.
Right. Committee, what do you want to do? Senator
think
Bennett.
So I can't remember whether there's a provision elsewhere in this that describes the respondent as being the state's attorney who prosecuted the case. And I can't scroll this because I'm not in control, but I understand the logic of making it clear that it would only be the state's attorney's office that prosecuted the offense or the attorney general for the rest of this provision.
Yeah.
Otherwise, your potential for forum shopping is there.
Yep. Okay, so if we could insert language that makes it clear, to me anyway. Is the committee okay with this language? If it's just, as long as it's clear, it's just the petition to waive the waiting period?
Yep, I am.
I am as well.
Yep.
Moving on to page 10. This has to do with the restitution.
Right, so this is new language that we added that is getting at the issue of a person's eligibility for expungement or sealing if they were serving a term of probation that was dependent upon their payment of restitution. So it provides that anyone who's serving a term of probation for a qualifying offense that's dependent on their payment of restitution becomes eligible for sealing or expungement once they've satisfied that restitution order, as long as the other eligibility criteria that are set forth in the statute are met.
Bryn,
Yes.
I may be confusing something, but I thought that was already the case. Does this change existing law, or does it make
I think what changes it is that there are waiting periods that are imposed for when a person completes, satisfies the judgment.
Yeah.
And so I think that the idea here is that once a person has paid their restitution, then those waiting periods don't have to apply. If a person completes their probation at the same time that they complete their restitution order. So I
I
think
see.
what changes it is it makes the person more quickly eligible to have their record expunged or sealed.
Okay, got it.
Bryn, what page is that?
10.
Thank you.
Page 10, lines 8 through 11. Everybody okay with this?
So just a question, Senator, and to Bryn. So does this mean, I mean, presumably the person would have to be discharged from probation at the same time.
Yes.
And that's what really would start the clock running. In other words, if they've paid the restitution, and that's the only reason they're on probation at that point, presumably they would be discharged from probation, and that would start the clock running on whatever time frame this offense falls under.
Yeah, but does that line up with the probation bill?
That's why I was asking, Senator,
That's 45.
So will you ask the question again? Does it line
Does
up?
this
with the-
line up with S45 where you can get off probation? I'd have to look at S45.
in other words, Bryn, I don't think, unless you tell me if I'm wrong, I don't think you want this provision to mean that if they're on probation and there is these have to be an old case where it's a condition of probation, they pay restitution, because we do not do that anymore. But presumably if they've then paid their restitution in order to be eligible for sealing or expungement, they would still have to have completed their sentence, i.e. they'd have to be discharged from probation.
Yes.
Okay.
Yes.
Judge, what about those old cases that somebody, for instance, has been given a probation term of, say, 5 or 10 years?
You know, I think if, just my opinion, Senator Benning, is that if someone has completed restitution under one of those old probation or restitution while on probation orders, they should be encouraged to come in and then petition for discharge from probation, if that's the only thing that's keeping them on probation.
I'm not going to disagree with you, but this would enable them to apply for relief under the expungement statute, whether they're petitioning the court for discharge or not.
That's why I was asking the question, because I don't think that's what would be intended. I mean, I agree with you. That's why I asked the question, because being eligible for sealing or expungement still requires them to otherwise qualify, which would mean they have to have completed their sentence, and whatever the waiting period is for sealing or expungement would have to kick in.
I just don't want to have that term of probation and a person petitioning the court, especially in the days of COVID, to hold up a potential expungement.
Well, they're going to be held up if, in my view, if they've got to complete the sentence, with restitution only being one portion of it. And if that's the only thing that's keeping them on probation, that's why I'm saying at that point, upon completing the restitution judgment order, they should be petitioning the court to be discharged from probation, which would then make them eligible for whatever the time frame is for sealing and expungement.
Let me ask it a different way, Judge. Is there any harm in leaving this language just the way it is?
And unless someone interprets it, and I guess that someone would be a judge or a state's attorney, I guess, or an individual, interprets it that completing restitution alone makes you eligible for sealing and expungement. And I just don't understand that's really what you want here.
Well, I think we agree that this deals with only old cases because we don't do this anymore. But if a person who is pro se approaches the Attorney General or the state's attorney and asks for an expungement, the state's attorney and or the Attorney General are generally not going to petition at the same time for a discharge from probation. That would normally be the defendant themselves who do that.
I agree.
So I don't want to have a situation where a pro se individual is still on probation, can't get off probation, and can't get the restitution, I'm sorry, the expungement given to them because they've got assistance of counsel, if you will, on the one hand for the expungement, but not on the other hand, unless they go through a more formal process to have that petition for discharge granted.
If I understand your question, Senator, you would then be asking the court to consider sealing or expunging a case that is still a live case. In other words, it's still, the person is still on probation for that case. And that just
Yeah, I see your point.
doesn't make sense.
If I might, I think the language in here is a little confusing. I think that what was trying to be accomplished here was to deal with cases like Ms. Reddick, where
Right.
someone was put on probation, and a term of their probation was paying restitution. And the only reason that they stayed on probation for 10 or 15 years rather than 2 or 3 years was because they had to do their restitution. And now that they've completed their restitution, it would seem, incongruous to make them wait 10 more years to seek expungement, just because they were one of the unlucky few who's still left on probation with a restitution as a term of probation. And so I think that what this language is trying to say, it doesn't quite say. And I think maybe if we modified it to say something along the lines of, and I'm just doing this off the top of my head, so I don't know that this will come out quite right, but that if a person is serving a term of probation that contains a condition requiring the payment of restitution, that they shall be eligible for sealing or expungement after, and I'm just making this up, but it could be something like, whatever the waiting period for that offense is, after that period of time has passed since the statutory minimum term of the sentence has passed, as long as the restitution is fully paid off.
Marshall, I appreciate that thought, but I think what I'm going to do is I'd like to get it right before we vote it out. So we have some time Friday morning, and at the end, after we've gone through the bill, this may be the only change that we need to make, but I'd rather have you and state's attorneys and Bryn and the judge all on the same page on this so that we do get it right, and make sure that we're dealing with that situation. So I wonder, maybe we can come back to this if we have more time this morning, or if we need to, we've got Friday morning to take care of this.
And I don't disagree with the concept behind what it's trying to do. It's just we need to straighten out the language.
Yep. Okay, so could we move on and then either come back to this morning or see if that's the only issue that's outstanding for the committee? We can deal with it Friday morning. You're going way through this thing.
Yep. So the next change is on page 14 and 15. We've just added some subheadings intended to make those specific subsections of the expungement statute a little bit clearer. The next substantive change is on page 17. So this is these are the requirements for sealing or expunging a qualifying felony property offense. And then transporting regulated substances offenses. So currently, under the current language, it's qualifying felony property offenses are barred from expungement after sealing the record if the person is charged with a subsequent offense. And the language here was recommended. This was a part of the recommendations that came in from legal aid. And what this does is it narrows that limitation, the subsequent offense limitation, so that a person who is convicted of a subsequent offense is still later eligible for expungement of that sealed record unless they commit a listed crime within 7 years prior to their petition, or a non-listed crime within 3 years prior to their petition to expunge. So rather than cutting off people who are later convicted of a subsequent offense, it just narrows the eligibility for expungement for these types of offenses.
Any thoughts on this section? Anyone, committee or audience?
Well, the 3 years, I'm wondering, I heard Bryn say that came from legal aid. How does that accord with, that seems like the quickest interval I remember us considering in terms of these waiting periods. Is that so, Bryn?
I will need to check on that.
I can't remember any of the other language having something that quick, because you could have somebody who 3.5 years ago was convicted of an offense. That's pretty recent. So that's my only question there.
I would just, so this is once a record has already been sealed. I want to point out that we're not talking about the waiting period to have it, have the record dealt with at all. This is for records that are already sealed, to expunge those already sealed records, just to be clear.
Yep. I think my question's the same.
Okay.
I'm just wondering if because maybe I'm wrong, but it seems like these things will eventually all move to a common point. And are we establishing 3 years as a time frame? It just seems 7 years, 10 years, those all seem like intervals where you could judge someone's changed behavior, or a demonstration of that the fact that their other offense was an outlier.
Everybody okay? I'm not, I wonder, I've got to take care of something.
Okay. Does anybody have comments on that piece of language? And I can't see you, so you just speak if you do.
Good morning. This is Mairead O'Reilly from Vermont
Hi.
Legal Aid. I'm not sure if anyone from the committee wanted to speak, but if not, I'll
Yeah, go
speak
ahead.
to this for a second. So the
Be
intent,
upfront about what happened. Part of old age is you start bleeding sometimes.
oh wow.
I need to get rid of it.
So part of the intention
So-
behind this. Oh, excuse me.
Where are we on this one? You want to come
Uh,
back to this, or are we?
Mairead is going to speak to it, if that's all
Okay,
right.
good.
Yeah, so the intention behind this proposed amendment, and it is a bit different from what we had originally proposed, but the intention is that these timeframes are supported by the literature on recidivism, which say that for minor crimes, a 3-year period of time is really sufficient to show that a person has changed their behavior. For some of the more major crimes, 7 years is the comfortable mark. If a person has not recidivated within 7 years, there's not a real threat to public safety. And, that person is just as likely as anyone else to commit a crime. So I was just attempting to sort of track our policy with what the literature suggests. I think in my original proposal, there were a couple of additional crimes. It wasn't just the 53017. I think there were also some, I had listed the sections that laid out some of the felonies and the predicate offenses as well, and was really just looking to get the misdemeanor crimes as the ones that where the look back period would only be 3 years. If that makes sense.
Is there anywhere else in this set of statutes where we have 3 years?
Not yet. And this has, been sort of a continued conversation that we've been having to attempt to sort of track that the research with how our laws are being drafted, but it was a proposal, so.
Okay.
Senator David
Yeah.
Chair, if I might comment just on the drafting and what I think the implications are. And Mairead can certainly correct me where I'm wrong. But as I read this proposal, it's not actually shortening the timeline. It's just changing the conditions for eligibility after the time has run, setting aside the waiver possibility for now. So yeah, section 1 of this part of it notes that you've got to wait 8 years for the sealing. And then section 2 still requires an 8-year waiting period before the expungement can happen. All that's changing is the conditions which allow an expungement to happen. It's still got to wait the 8 years, but now they're saying if you haven't committed these offenses in this period of time, you get to have that expungement. If you did commit one of those offenses, then you got to wait, or basically it disqualifies you. But the change is not so much shortening the waiting period as just changing the conditions that you have to meet after the waiting period has run.
Well, conditions for eligibility.
That's right. Yeah. So you've waited your 8 years, and if in the 3 years prior to that you didn't have an offense that's outside of the listed offenses, you qualify, but you still had to wait the 8 years.
Well, in a sense, I mean, it's semantic, right? If you committed a disqualifying crime, then you haven't waited the 8 years, right? Because you'd still have to wait longer to get past the disqualifying crime. Does that make
That's
sense?
right. I think we're understanding each other. I think that's right. And I would just reiterate that the 8 years still has to be waited in any case.
Yeah, I guess unless I'm reading it wrong, it just sounds like
if I were reporting this on the floor and somebody asked me a question about it, which I don't plan to report this, by the way, I would be hard pressed to try to explain this piece. And I think it's just not clear to me in reading it.
Yeah.
So if you're not convicted of a listed offense within 7 years prior to petitioning for expungement, or you have not been convicted of an offense not listed within 3 years of petitioning for expungement.
It's kind of frustrating
I'm a
not to
little
be able
confused.
to scroll this because I keep wanting to scroll up to see the section. What are we talking about?
Yeah.
We're looking at a sentence in isolation. Okay, stop there. A criminal history record sealed pursuant to the subsection 8 years after the date on which the sealing order is issued. Okay, so there's a clock after sealing of 8 years, and then 8 years goes by. You can get it unless you were convicted within 7 years for a listed crime or 3 years for an unlisted crime. So if someone, let's see, if someone in the 6th year of the 8-year clock committed a crime that was unlisted, they would be ineligible for another year. So that would make the elapsed time 9 years before they could get a sealing. So the 3 years of petition or the 7 years just adds years on to the 8-year clock. That's the way I look at it.
I agree with that, Senator. That's how I read it.
Okay, so my question is, if we say 3 years for unlisted crimes, we're rendering that addition of years shorter than in other areas, it seems to me. We're sort of we're reducing the look back period to an interval that's shorter in other areas, shorter than in other areas of our expungement and sealing. So you could wind up with somebody who waited their 8 years, or committed a crime just over 3 years ago, and they would be eligible for expungement. And that I understand what Mairead is saying, which is it's an attempt to nudge our sealing and expungements towards shorter periods because the literature goes there. But it seems to me somewhat at odds with what we've been doing, which
Yeah,
had
this-
longer periods.
This person has committed 3 crimes. And the last crime was only 3 years ago.
So-
I don't know if that was to me, but I can answer. I mean, I think
Yeah, please.
let's say
Anybody.
it's 2 to keep it simple. And the more recent crime was 2 years ago. That one isn't eligible, most likely for, obviously, so again, I'm going to set aside waivers here. That one isn't eligible. So that one's still on the books, but the one for which the individual completed the sentence at least 16 years prior, because remember, this is 2 8-year waiting periods we're talking about. That one would then be eligible after they've finished out that 3-year period. So it's a very old offense we're talking about here.
And again, the intention is just to ensure that people who have felony property crimes are not barred forever from expunging those offenses. So under the bill as introduced, petitioners would be eligible to seal it, and they would be barred from expunging if they ever had a subsequent offense after the offense that's been sealed. Our language was an attempt to rectify that, to ensure that after some amount of time, and as David stated, it's quite a bit of time, but after some amount of time, that record can actually be, wholesale expunged.
David, could you just explain the 2 8-year periods? Now I'm again confused.
Yeah, so again, Senator, the challenge here might be just not having a scrollable text, but we're looking at subsection 2, and
Yep.
subsection 1 lays out the 8-year waiting period before you can seal the record.
Yeah.
Subsection 2, it lays out the second 8-year waiting period before you can go further and expunge the record.
Yeah.
And again, Mairead is right that what this amendment is doing is simply saying that you could remain eligible for expungement even if you commit a subsequent offense, whereas the prior proposal basically said you lose the ability to expunge forever.
And okay, so if I could just say, I feel as though the whole push behind sealing and expungement is to help people who have obviously stopped committing crimes. Long periods of time have gone by, and in which case the state goes through a great deal of bureaucratic effort to help them by sealing and expunging, to the extent where expungement used to mean literally pulling out tapes and erasing things. So, we've been doing a lot of good faith effort. If somebody committed a crime, even an unlisted crime, just over 3 years ago, should the state be in the business of cleaning up their earlier record if they're, in 3 years ago is not a long period of time. I think at that point they're actively showing criminogenic behavior. Why would the state go to the trouble of cleaning up their past record for them at that point?
Can I weigh in?
Yeah.
I do think that if somebody has committed a crime and 16 years goes by, in this case, it would be 13 years goes by and they haven't done anything. And then they lift a pair of socks or steal some food at the grocery store or whatever, that is not, I mean, I think that we should expunge their old record. I just think that this is putting people, why would anybody try? Anyway, I think that we need to, I like this. I think that if somebody commits an unlisted crime, which could be pretty minor within that 3-year period, they've clearly been good for 13 years. And now they commit some minor, some misdemeanor, and we're going to slap them on the hands for their actions 16 years ago. We're going to go back to that. So I like this, actually.
But this would.
It may be
would include-
confusing, but I like it.
but this would include unlisted felonies.
Yep.
Oh,
It
you
would.
said misdemeanor,
Well, it could be a misdemeanor.
but it could be a felony.
It could be.
I'm in the Phil camp.
This is James Pepper from the State's Attorneys.
Yep.
You know, I was having a hard time really understanding this provision as well, but I think I have it now. But one just complication that I would throw in there too is, you know, you're talking about subsequent offenses that are listed offenses. Someone could be under sentence and seeking to expunge a prior felony. And say what you will about habitual offender statutes, but that could have an implication on if you expunge a prior felony that was one of the, you know, 3 prior felonies that led to a habitual offender enhancement, then all of a sudden, you know, there would be a PCR, a post-conviction relief petition to eliminate probably the sentence, that enhancement. So there is another complication here that just we've started to see a little bit with the expungement expansions in the past, but it's just one complication that I think should be brought to the attention of the committee for this provision.
So you're opposing this?
I think, you know, with respect to the
I should say the state's attorneys are.
the subsequent offenses that are listed offenses where someone might still be under sentence, you know, attacking the underlying trying to expunge the underlying convictions is somewhat problematic. And I think that that's why, you know, having them sealed is a good path to go down. But I think the state's attorneys, and I don't think I really fully understood the implications of this section until we, you know, the committee just discussed it. But I think the state's attorneys would be opposed for several reasons.
May I just ask a question for clarity? Because I think some of that,
Yep.
some of what Attorney Pepper just said confused me. So Pepper, are you saying that there's cases right now where someone has expunged a felony that was the basis for a habitual offender enhancement and then filed a PCR to try to undo the habitual?
I think that that's what this would lead the door to.
I'm just trying to clarify because you said it's happened to some degree. What can you tell me what's happened to some degree? Because I was asking questions like this of our prisoners' rights office, and I didn't hear anything like this. So it's kind of a surprise that I'm hearing it. And I'm just trying to clarify what's actually happened. Have there been cases when people have filed PCRs to undo a habitual based on, because they've expunged one of the felonies that was the basis for the habitual?
What I'm saying is I think this opens the door to that. I can ask the state's attorneys if they've seen it in the past.
No. My question was specifically just because you said that this has happened, and that was concerning to me because I had tried to sort of look into.
Well,
this could have, and
Marshall,
if it hasn't happened, that's a different story, and that makes me a lot more comfortable if this hasn't happened.
I hear James saying that he is worried that may happen, and he's willing to check and see whether it has actually happened. And I think
that's
yeah,
great.
I take
was
your
just saying
correction.
because it had happened, and that was totally contrary to my information. And I wanted to make sure before I said anything that I was using accurate information.
Well,
Because it doesn't, to me, it had not sounded like it had ever happened, but then James was saying it had.
we're gonna hold this one until Friday, I guess, and hopefully Senator Nick will be back. But if I might add that, Bryn, I would like to see it an alternative language that only allows a misdemeanor. I don't disagree with Senator White's comments about hopefully somebody stealing some food would not be prosecuted in the state who was hungry. A small amount of food, not a trailer truck. But I would like it limited to a misdemeanor.
Okay, and do you have a time period that you'd like?
No, the 3 years is,
Okay.
for me, right now, I'm trying to figure out exactly what this does and give Pepper and Marshall a chance to look further at it. But I think at any rate, if we were going to do this, I wouldn't want to see felonies included in it. I would prefer personally, if I'm going to vote for it, to say this is misdemeanors and people can make a minor mistake and that's a misdemeanor.
The other thing that I probably should have added before is my reading of the bill as introduced is that any offense that was committed after the sealed offense, even if it was very close in time after the sealed offense, would vitiate the opportunity to get that sealed offense ever expunged. So does that make sense? That was also part of the concern, that just because of the timeline of when offenses were committed, if you're eligible for a sealed offense and then the very next year or 2 years down the line, there's another offense on your record, that sealed offense is forever sealed. And I was attempting to sort of fix that as well, because that just seems a little bit illogical and unfair. I'm not sure if there's a way to fix that.
I think we need a roadmap. Why don't we keep moving on? See if
I hesitate to say it, Senator, but I have to after listening to the discussion that when we talk about automatic sealing and expungement, this is a good example of why it's not. And that's why I'm glad to see the language in the latter part of the bill that we can at least talk about a different process.
I was just gonna, before Judge Grierson spoke up, I was gonna say, this reminds me of his periodic calls to consider getting rid of the 2 tracks and just having 1 track. Because I feel as though we're creating a web of interwoven requirements and timelines that, I'm just thinking about trying to count days of good time and how complicated that got. So, I would be really at a loss to try to take an individual fact pattern and figure out what the actual abilities for that person were in terms of sealing and expungement.
I didn't like the 2 tracks when we first started talking about this. My only recollection of why sealing was requested was that there were individuals who might be migrant workers who needed to have some proof that they had an actual conviction out there. And I'd never understood the logic behind that, but this has never made any sense to me, and I wouldn't want to be the one on the floor trying to explain this process at all.
the sealing, I think, was also because you have certain predicate offenses, and without a process of sealing, how do you get back to the predicate offense? If it's a second,
I guess the other way to answer that would be that there's only one thing called an expungement, but is in effect sealing. In other words, the records are still there. I forget who has testified numerous times talking about access. The question always being that it's about who has access.
Yep.
Who was that, Jeanette?
I think it was, well, I do know that it was the guy from from Council of State Governments.
Oh, that's right.
Did talk about that, and that most places have only one process, but then there is limited access. There's only certain people can have access and for only certain reasons. And that seems to me to make imminent sense to do it that way.
Yeah,
I mean, I'm not going to take credit for that, Senator Baruth, but that's
Okay.
what I've been trying to say for some time. It's access, meaning who, for how long, and under what circumstances. That's what we should be focusing on.
yeah.
Yep. And that we heard that from a number of people, including Judge Gerson. I'm sorry.
No, don't worry about it.
Moving right along to line 10.
Right, so are we moving past this section? Because I just wanted to point out that subdivision 3 has that, that
Seal or
word,
expunge.
right, it allows that record to be expunged with the stipulation of the prosecuting attorney. And
May I ask a question before we move on?
Yep, which, on the expunge or on the
Well,
upper?
well, my question is, since we have heard from many people and now seemingly 3 committee members about having only one track here and limiting the access, as was suggested by Judge Gerson, should we even start re-looking at the way we do this at all and not passing an expungement bill, but just redefining the whole system? Is my question.
Okay.
so we have one more change to get through before we get to the study committee. Maybe talking about the study committee would help everybody think about that question that Senator White just posed.
Yeah.
Okay.
Thank you.
So the last change before we get to the directive to the Sentencing Commission is another request from legal aid. It includes some language that would require the court to make a reasonable effort to notify people who have had their records sealed that they may be eligible for a subsequent expungement after a required waiting period. And we mirror the language that you used in S45 about notice to victims about what a reasonable effort to notify means.
Okay.
Okay. Any discussion about that, or shall I move on to the, okay.
Mr. Chair,
Yep.
could we hear about that from either the, maybe Judge Grierson, in terms of that's, as I understand it, that's putting a requirement on them that they don't currently have? Is that correct, Judge Grierson?
Yes. So the original language that was proposed was making the reasonable effort to notify the person, and I suggested to Bryn that she incorporate that language from S45. I mean, the way I see this playing out, if the person comes in and their record is sealed, and maybe it's an oversimplification on my part, but I would think that would be the time to say, okay, the order is granted sealing your record, and whatever notice we put in, I would think it would be simple to include it in the sealing order. So I don't see it as having a significant impact on the court, because we'd be issuing the order sealing, and that's would seem to me to be the appropriate time to give them notice that there is a possibility of expungement in the future. But
So would the sealing order go out by first-class mail to the person's last name?
generally speaking, that's the way they go.
Okay,
Because we've
Right.
had contact through, in other words, if the state's attorney or the attorney general's office was ever bringing this petition, they've obviously had contact with an individual. So presumably somewhere in that process, they would provide us with a current address. If they don't, then we're going to be looking at an address that is probably anywhere from 8 to 10 years old. So I'm thinking that if our files are updated at the time of sealing with an address, we issue the order, that would be the time to include in that order, oh, by the way, you have the possibility of expungement. But our notice would be pretty limited because you can see all the complications of someone being eligible for expungement. It's not going to be anything other than saying there's a possibility of you having this record expunged in the future. So I don't see it as having a significant impact, if that was your question, Senator.
It was, thank you.
Moving right along.
Okay, so I'm going to move to the last change, which is the last section of the bill, amending the directive to the Sentencing Commission.
Yep.
So this, we've just added some language here to require the Sentencing Commission to do two things: to consider how to automate the process of sealing and expungement, and also to develop a comprehensive policy that provides an avenue for expungement for all offenses except for Big 12 offenses. And it directs them to report back to the Justice Oversight Committee by October 15th of this year on their recommendations for how to make all criminal offenses eligible for sealing or expungement except for Big 12s, and implementing a petitionless process to seal or expunge conviction records that both provides notice to the prosecuting attorney's office and also the opportunity for the prosecutor to oppose the sealing or expungement.
Thank you. Has anybody got any problem with that part?
No, but I would like to add my suggestion.
Well, I thought we were going to talk about yours. Yeah, I thought we were going to talk about that more on Friday.
Oh, okay, okay.
Um,
I thought
after
Brent said when
people
we
have had
got
a
to
chance to think about how do
Okay.
we, I think the issue you raised is we have some crimes that are sealed, some crimes that are expunged, some crimes that can get sealed and then later expunged. It does create a confusing track, but I think more importantly, who has access to those records? One was, we did hear, as Senator Benning noted, from folks who may have had immigration issues, that they needed that record to prove something. So that would be a person who would have access. Where there's a subsequent offense, somebody may need access. A DUI, for example, that was sealed. But I guess that could be part of the study that we asked the Sentencing Commission to look at. It would be a huge change. And then the other two issues are that have to do with Section 2, number 6, the subsequent offense. Who can stipulate it? As a new incident. We said we come back to that. And then what we just talked about, which is the page 17, lines 1 through 7. I'm going to include lines 1 through 7, even though not all of it is highlighted.
So I realize that making such a huge shift is it's a major step, but it seems to me that every year we make the current system more complicated. And as you said, we need a roadmap. So we keep trying to somehow get sealing and expungement coordinated, and it seems to me that we are every year just making the whole system a little more complicated, and that we might want to look at, is this the system we really want to keep? And should we look at a different system?
Pretty easy to put the 2-track question into this study committee.
Yeah.
I would hate to try to do it ourselves with the short time we have now, and then all of a sudden find the House is rejecting the bill altogether because they just can't grasp it.
Yeah,
I think it's better to put those questions into the study. I agree with
I think so
Senator
too.
But then back
Senator
to,
Baruth.
back to Jeanette's earlier question, I think, which is, should we, if we're sort of acknowledging the logic behind examining the two-track system and maybe getting off it, should we this session pass a bill that adds more layers of complexity that will have to be erased.
Yes.
So
I mean, no, we should not.
I know that's a tough question because we've done a lot of work on this bill. But you know, at some point we will have to bite the bullet if we're gonna reverse course and go to one track. And so the question would be, do we do that now, or do we hold that question till later and act now as though we're not considering it?
Since
there
we
something-
substantially passed this bill last year, I'm not of the mind to bag the bill until we get more information. So I think that this bill has some important provisions. We heard, before the pandemic, before the pandemic had already started, I would say, but before the governor's emergency order on March 13th, that led to us going remotely. We held a hearing in Winooski, and I think this bill addresses a lot of those concerns from many members of the public, and I hate to lose the bill. If anything, I think we've come a long way, and so I would suggest we do the bill, but we take a hard look at the three issues on Friday, that we add the question that Senator White has asked the Sentencing Commission to look at, the seal or expunge and that we make decisions about the other two issues on Friday morning.
Senator Sears,
Yes.
there may be some parts to this bill that I agree should be passed now that don't add to the complexity of the two-part system. But there are some that add more complexity to it, and maybe we should look at those and see if it's wise to pass those, adding those complexities, and just keeping in the ones that address some of the underlying issues, whether it's sealing or expungement.
Okay.
When the committee's done, if I could comment on a section
Section which?
On the section about the work of the Sentencing Commission, I
Yes.
just remind the committee of a couple of things. Last spring, when the pandemic hit, you'll recall, I'm pretty sure it's Act 95, actually suspends the whole process for processing expungement requests. Now, that's not to say they're still not being done to some extent. I think Sarah George had testified to that effect, but there is a provision that allows the court to suspend processing of those requests for 120 days after the AO 49 ends. And as of right now, of course, AO 49 goes until the end of March. Whether or not it's extended, I don't know. But so there is this lag time that is possible where no matter if this bill passes in any form, that there still is going to be a backlog of these types of cases being processed. It's number one. And I think the committee wants to be aware of that. Number two, I noticed in the language talking about, and we've talked periodically in this committee as well as House Judiciary about automatic expungement. And in my view, automatic literally means there's no discretion involved. And you can see as you go along in this process that we've currently operating under, there are any number of situations where some discretion has to be exercised. And it should be exercised by law enforcement and the prosecutors and not the court. So when the term automate is in there, if that's realistic, we've got to devise a system where there isn't any discretion. A timeline comes and the file is sealed. And the only other thing I would add to that is that, now would seem to be a good time to look at this system, because we are now on the verge of the court having one case management system. VCIC obviously has all of their records centralized. we have an opportunity to remove this and put it into an entity that their sole function is to process requests and deal with these records as one entity. And I just think it's a good opportunity to look at the current system and see if we can find a way of improving it for everybody along the way, whether it's state's attorneys, VCIC, the judiciary, and the litigants whose records are affected by this. So I would hope we could continue along those lines.
Well, we're going to take a break and come back at 11:30. Take up robocalls. I think I got one while we were. While we were meeting. So Peggy, if we come back at 11:30, I don't know exactly what time. Right now, 11:24, so it's a
Yep.
5-minute break.
Okay, I won't put the, I won't shut down the YouTube. If everybody could just shut off their video and audio, that'd be great.
Will you be going just to the robocall issue? Or are we done with this?
I believe it sounds like we're going to robocall.
I have to go to another meeting.
Yeah,
Peggy,
I think you're okay.
If you
Yep,
need me, just email me or text me.
Yep, will do.
Thank you.
Thanks.
Chris Delia, I am sorry. You are on mute and we are live, but I am sorry.
I hate this dreaded mute button. Drives me nuts. Madam Chair,
Sometimes
we're good. We're
Okay,
good.
all right,
I
good.
get it.
Thank
Hi.
you.
Believe me, I've gotten myself into enough trouble with
You know, my friend said when I ran for office that my biggest problem would be my mouth. And it's gotten me into trouble sometimes.
True for
Me
all
too.
of us.
Yeah, true for all of us.
You live by the mouth, die by the mouth.
Somebody told me a long time ago, you are the master of the unspoken word, and I try and remember that.
Oh,
Sometimes I forget.
Peggy,
We're
we'll do, Friday will be S7 at 8:45 to 10.
Yep, I figured as much. Yep.
I'm sorry I couldn't be there. I did hear a lot of what was being said and was looking at the screen periodically, but I had to deal with something.
Joe, that's like a really impressive book display there. You got
I've got more of them if you want them, Era.
No.
Going through it. Oh, they're all
I'm
there.
always-
You can't see them.
Oh, now yeah, there. That's
I'm
Wait,
always impressed when people's bookshelves are like this. A lot of mine are like this. I
Edmund
mean,
Burke.
not the shelves themselves, the books.
Interesting. Edmund Burke is an amazing guy.
Indeed. Long before his time.
Yeah, he's somebody that I teach a lot. You know, basically his philosophy is aesthetic theory, but then his whole political stuff toward the end of his life is
Yep.
amazing.
He should be required reading for legislators.
Okay. So as soon as David Hall's ready, I'm ready.
Ready, sir.
Great. Do we have a redraft of robocalls, or are we just?
We have the amendment that we started working on last time. Didn't get all the way through, I guess.
Yep.
Should I pull that up on the screen?
Yes, please do.
All right. Here we go. So hopefully you're seeing a strike all amendment to S11. This
I
is
am.
David Hall, Legislative
Yep.
Counsel. S11 is a bill relating to prohibiting robocalls. And last time I was taking you through this strike all, which still adds this new section of law in Title IX, but now, also includes this intent section, which would be codified, but the real purpose of subsection A, again, is to try to basically say in plain English, what it means to have a law that's coextensive with federal law. As I've tried to convey, the difficulty with actually importing the federal law itself into ours is that it comprises two separate acts plus the regulations, which the regulations themselves, incorporate by reference other regulations, including pieces from HIPAA concerning, what it means to be a healthcare provider or a health message that is allowable for the purpose of robocall. I mean, the easy way to explain that is your prescription is ready, right?
Mhm.
I mean, that's a robocall most people probably are not gonna object to. But to get there, there's no easy way to do that without, going deep down the rabbit hole of 47 USC 227 or 47 CFR 64.1200D. So to try to avoid that morass, which is changing constantly, I don't think I mentioned last time, some of the provisions in the regulations at the federal level that govern this stuff actually just took effect on February 12th. I mean, it's a very, because it's, related to multiple agencies, the FTC and the FCC have regulatory authority. And then the technology obviously is constantly being updated. And then lastly, the most recent federal legislation, the TRACE Act, which we discussed last time around, which requires the largest telecom providers to adopt this shake and stirred system where they're doing sort of a front end verification of who is making the call and that it's a legal number. They're trying to weed out these calls before they even get to you. But all of this stuff is happening at a rapid pace through orders and rulemaking and new legislation as of the course of this past year. So to try to capture all of that in words in the state statute would be very complicated and troublesome, I think, and therefore, the approach that's easiest but also clearest, I think, was to try to say our state law is coextensive with federal law, and then we looked at that FTC webpage together and said, here's what it boils down to at a general level: tons of nuance. And, frankly, if you're in the business where you want to use robocalls for certain reasons, like, you've got a regulatory compliance burden, no doubt about it. And you need to know what the federal law is and what the regs are. And it's hard. There are law firms whose job it is to create matrices and guidance documents for businesses who want to utilize this technology. But in a simple nutshell kind of way, here in our statute, there's a plain statement that your intent would be in A1 to create a state law prohibition on the use of automatic telephone dialing systems and on the placement of robocalls to Vermont consumers. It's coextensive with federal limitations created in the TCPA and the TCF APA. I do say in A1, I use the word robocall as a matter of statement of intent, again, as of a plain English kind of conveyance of what you're hoping to accomplish. Understand that in federal law, there is no definition of robocall. And we could try to make one up, but if we do, my concern becomes what we make up might be interpreted to be different than federal law, which says artificial or pre-recorded voice. That's how they sort of capture that component of it. And then the automatic telephone dialing system is the other component. In A2 here, plain statement, you want to continue to permit certain robocalls to the extent they are allowed under federal law, including, so these are the examples. This doesn't change the substance of the state legislation, which is, if it's legal under the federal law, it's legal in Vermont. If it's illegal under the federal law, it's illegal in Vermont, and we can pursue state law causes of action. But here, we've looked at these before. Calls made for an emergency purpose with prior express written consent of the called party.
David?
Yes, sir.
Sorry to stop you there, but does express written consent include clicking a box?
It could.
So we did this with automatic renewals.
Yep.
You remember in economic development?
Yep.
There are ways to strongly nudge or even force consumers into clicking a box in order to move forward, and you can have language down deep that allows robocalls going forward or automatic renewals. I'm not suggesting that we change it if this is the federal law. I just wanted to be aware of whether that was allowed.
I assumed it was, because with my pharmacist, I get text and I signed up for it by clicking a box. I get text when my prescription's ready, for example.
Yep. I just pointing out it is a potential loophole for people to,
Yeah,
you know.
it is.
Yeah. Okay, go ahead, David.
Sure. Yeah, that is, so the federal standard in most cases is prior express written consent. Not all, and again, it depends on what kind of line they're calling and whether it involves advertising or telemarketing. There's lots of rabbit holes you can dive down, but this would be something that's allowed. If a consumer has given you prior express written consent, there should be no reason to negate the consumer's preference, I suppose.
Yep.
Under C, calls conveying messages that are purely informational. This is this is one place where the nuance of federal law is difficult. The statute says you can't do this unless the agency by regulation allows you to do this in certain ways. And then there's a regulation that comes after that and says,
Would that include that my warranty is expiring and this is my last chance? I mean, they could argue that's informational.
Right. Well, the way that the federal regulation works, it can either be a call that is not commercial or that is commercial but doesn't try to sell you anything. So it depends on whether or not they're trying to sell you or advertise or telemarket to you, or if it, by contrast, is just a legitimate, conveyance of information. If your warranty
They're
is
trying to sell me
actually
a warranty, but it's my last chance to do it.
right,
So they're
Yeah.
informing me.
I mean, arguably, but it's also it's illegal to try to deceive or commit fraud or abuse a consumer. And I mean, at least the warranty calls I get are for vehicles that I don't even own. So
Yeah, actually, I'm getting mail on that too. My 2012 Fusion's warranty has run out. Well, I feel bad for whoever owns it now.
yeah, they're still trying to buy back my car that I sold in 2013.
Okay, moving right along.
All right. Calls concerning the collection of a debt, but not including calls that attempt to sell consumer services to reduce debt. This is not to be confused with the specific carve out for collection of debt owed to the federal government, which I think I mentioned before. The Supreme Court actually struck down that part of the law because they found it gave preference to that content-based speech over others. And so the federal government no longer gets its own carve out and priority under the statute, but a non-commercial collection call is allowed as long as they're not trying to tag on, help us, we'll sell you this service to help you eliminate your debt in 90 days or something like that. That's illegal. Still can do political calls. The calls from healthcare providers I mentioned. That's a very general statement. Again, there's nuance there about if you're on the list of the kind of healthcare provider and the nature of the call, and it's not selling you anything, and it's HIPAA compliant, et cetera. And then we talked about the messages from charities, either directly
Yeah,
from them.
I want to clarify something I said the other day. I did not mean necessarily a huge percentage of charities are scams. And I did not mean to robocalls from charities, a huge percentage of scams. I did not mean to imply that charitable organizations are necessarily scams. There are a number of well-intentioned charities who do great work and don't have huge overhead. They're either, my experience is that those that use robocalls, those charities that use robocalls are frequently either trying to, it's a scam, or secondly, they may be having huge charges for the administration of the fundraising efforts. So that rather than 10 or 15% of the cost of fundraising going to the fundraising, 90% is going to the administration of the fundraising, and only about 10% is going to the actual charity. And I just want to clarify that when I said that the last time we took the bill up, I did not necessarily mean the charities or stands.
So relative to the bills introduced, this does add the definition of automatic telephone dialing system. And again, this is from 47 USC 227, the Telephone Consumer Protection Act. And it's a defined term there. As I said, they do not define the term robocall, but they do define automatic telephone dialing system. So you'll see in C, line 14, the prohibition is on initiating a telephone call to a Vermont consumer using an automatic telephone dialing system or an artificial pre-recorded voice. So those are the two things that are verboten under the state law, to the extent prohibited under federal law. And the rest you have seen. Civil violation is a violation of the Consumer Protection Act, and there is enforcement capacity here in court, civil action, attorney's fees, penalties of $500 for first, $1,000 for subsequent, criminal penalties of 90 days, $1,000 or both, and then each call is a separate violation under each of those provisions. And lastly, the AG's office should work together with others, state and federal, to try to identify these callers and enforce provisions to the extent it can.
Do our bankers have any issues with any of this, Chris Delia?
Thank you, Mr. Chairman, for your record. Chris Delia, President of the Vermont Bankers Association. I will be brief. Number one, I greatly appreciate you adding the intent section and understanding completely the complexity of trying to capture all of the federal laws or regulations and not wanting to embed those in a bill here in Vermont. But at least the intent section gives people some understanding of what's allowable, if you will. So that's greatly appreciated. Again, I understand why you don't include a definition of robocall, so no issue there. But I do want to flag something for you that came up that I learned this week, and it's related to embedding the definition of auto dialer. And I think this goes back to David's comments again of the moving landscape of what's happening at the federal level. So it's my understanding that there were just recently arguments in a Supreme Court case regarding Facebook and versus, I think it's Duguid, D-U-G-U-I-D, and it's specifically dealing with the auto dialer definition. And there are several appellate court cases that come up with two definitions. So the Supreme Court case is trying to resolve that. I flag it for you because not knowing what may happen with the Supreme Court case, your embedded definition may change or may have to change depending on what they come up with. So I just wanted to flag that for you. It, again, is something new that I learned since your last hearing. And then the final thing is, I know David mentioned this in the previous hearing, because we've had two of our institutions whose numbers have been spoofed, they've still asked me just for a brief statutory reference to Vermont statute that would prohibit spoofing, if that would be acceptable to the committee. Otherwise, we greatly appreciate it. We understand what you're trying to accomplish and support that. We just want to, again, as I stated in my first comments in the first hearing, avoid any unintended consequences. So thank you.
I'm good with spoofing being in the bill. David, is that complex to add to the bill? Anti-spoofing?
Just put in no spoofing, David.
So we have a requirement that it's deceptively not simple. I think I emailed to the committee last Wednesday that a few years ago, you all adopted a law, went through finance, working with the AG's office to require that a person who is placing a telephone solicitation must provide accurate caller ID information. So they have to give an accurate telephone number, and to the extent the recipient of the call or the entity that is facilitating the call has the capability, they also have to provide an accurate number. An accurate name for the caller. There was one caveat that if you were making the call on somebody else's behalf, you could supply the name and number of the person on whose behalf you were calling. So for instance, if VPR hired a fundraising campaigner to do a fundraising campaign, they could supply the name and number for VPR rather than Peggy's solicitation services. Here's the problem. First, there's an issue about whether non-harmful spoofing is protected speech, and at least one circuit court has found that it is, and has struck down a ban on certain spoofing. And so you can't really, I'd be loath to recommend to you to say you just ban spoofing, because in some cases it's permissible. Under the federal law, you can't spoof in order to deceive or commit fraud, and that's the federal prohibition. And under the state law, there is a mandate that you provide accurate caller ID information. So if you were to spoof, that's technically right now a consumer protection violation. All that is
It's already illegal.
It's already illegal at the federal and the state level, and I'm not sure how to thread it in here at all, to be honest.
Right.
It appears in, this is adding 9464E, I think. I think the prohibition is in 2464C, maybe. So I can put some thought to try to how to reference it, but I'm not sure how to do that, to be honest.
Okay, well, I think we're better off.
2017, we amended 9 VSA 2464A to impose the affirmative requirement to provide accurate caller ID information.
Yeah, we've had actually, I've gotten robocalls from phone numbers like the one that the hospital uses, for example. So you answer it because you think it's the hospital pre-registering you, and somebody's spoofing it, I guess. So it's already illegal. Chris, any comment on that?
Yes, understanding that it's already illegal, we were just, again, wanting to avoid the unintended consequences of somebody looking at this particular section, and because a bank's number was spoofed, that it was a problem for them. So that's why I was just, if it's a reference to say that what you've got in 2464A, that prohibition applies here, but I understand if David can't thread it. I just want to make sure those entities that have their number spoofed are protected under this particular section.
Are there any other areas that people are uncomfortable with in this bill? The amendment that David just brought. So,
And again, I would just raise the issue of not knowing what the Supreme Court might do with your definition of auto dialer.
Where do we want to go, committee?
I don't have strong feelings one way or the other myself. I don't think it's a bad thing to mirror federal law. So I'm in support of the bill. But at the committee's discretion, whether it goes forward or in what form.
Well, I think we should amend the bill as seen in the draft that David just provided. And I realize that one could argue it's limited in scope and it won't have much effect, but the Attorney General did say it would be a good thing to have in a tool bag. But I also think, being that we live in a copycat world, if Vermont passes such a bill, other legislators around the country will begin to look at such a bill. And the more states that do this, the more I think Congress may listen and take some real action, particularly those that are from out of the country, where they can, but at least in this country, they can do that. I just think I haven't met anyone who told me that they really enjoy the robocalls. So I'll move, usually I don't make a motion, but I'll move that we amend S11 with the draft that David just presented. Is there any further discussion? Senator Bruce.
Oh, I was just seconding.
Just second, okay. Is there any further discussion? Hearing none. Peggy, could you call the roll?
Senator Benning,
Yes.
Senator Nika,
You're muted, Senator. You're still muted. There you go.
No. Now you're.
Did you say yes or no, Senator?
Yes.
Oh, thank you. Thank you.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. I'll now move that we report the bill favorably as amended. Further discussion?
Second.
Seconded by Senator Nitka. Peggy, could you please call the roll?
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator White,
Yes.
Senator Baruth,
Yes.
Senator Sears.
Yes. Who would like to report this bill?
I think it's your baby.
I'm going to just call on Senator Brock, my co-sponsor.
That's what I was going to say. Just ask him.
I'll report it, Peggy.
Okay. David, can you send me the clean version after it's gone through editing? Thank you.
And David, would you send me a few comments about why what's here and what's not here? That would be helpful.
Yes.
Report, take a poll of the Senate and see if anybody's in favor of robocalls, likes them. All right. Peggy, why don't we let go of adjourn the YouTube and